my learned senior colleague who's appearing for SSC, saying that even the Honorable Supreme Court says that benefit to all is the norm. Rather, I'm going to assist the court with the judgment of the Honorable Supreme Court, three judge, which says benefit to all is not the norm. It should not be encouraged at all. In this case, the benefit of all those questions which were found to be later on in the revised result was found to be having some discrepancy. The marks were given to everybody. Now, let me pause here for a minute and say benefit for all. Because I was also somebody who had attempted the questions as per the tentative answer key. But those questions that were rightly attempted by me, SSC later on says when they revise the result saying that there was discrepancy, therefore I'm giving marks to all. Now I only get 3 marks because I was anyway getting 3 marks for that question. Now discrepancy announced, I get 3 only. So what is the benefit that comes to me? Like Malad said, rightly pointed out last time that people who have not even attempted the question or have wrongly attempted, the best people are those people, Malad, who have wrongly attempted the question, who should have gotten -1. They get +4 now. Because I am not at all at benefit here, and this is not a litigation where I am trying to bring SSC down. I am somebody who has the last opportunity to attempt these exams. After this, my age goes. So for a mistake that is apparent on the face of it, and the honorable cat also recognizes it, should I be the one who should suffer? There should be some way that SSC should come up with to compensate that loss that I am suffering at least.
We'll have to in detail examine the effect.
Correct.
Let's pose certain questions to keep their whatever submissions you wish to make, please make.
Please.
You have basically shown us the chart.
Yes.
That how you are present.
Yes.
We have noticed that anything else.
Well, there's nothing else. Just two things I wish to point out. If Mullahs may grant me only 5 minutes more, because we had also prepared a very short one-page chart of 4 questions just to demonstrate to the court how frivolous the process of declaring certain questions was by the SSC. That was our challenge.
Gone into by the court.
All right.
You don't know it better than us.
No, absolutely.
Let us see. Please understand the limitations of a court.
Okay.
Court can't step into the foots of examiners or evaluators.
Yes.
We can't.
Absolutely.
If we are called upon, then it will create, because in law,
the judgments are both sides.
Opinions,
Justice Mahajan's judgment in Freya Kotari actually says that what Mullahs is saying, that it is not the court's domain to get into. We are aware of it. But Mullahs, can I show 2 judgments of one of a coordinate bench of a division bench of this honorable court?
Yes, you're welcome to say whatever you want.
Same case, similar situation, Mullahs. A coordinate bench has actually upheld what I am trying to say, that a question and how the court may, if it is found on the very threshold or on the face of it the court sees a violation by one of the institutes like this, can actually enter into this controversy. All I'm seeking is, Mullahs, just 2 things that I wanted to show. One is that judgment I will just show. Mullahs, may kindly have the impugn order for a minute. I was trying to read it last time, Mullahs, but then SSC wanted to show the questions. Mullahs, may kindly have the impugn order in item number 81, please.
Want us to go to item number 80?
Item 81, please, Mullahs. We have been referring to the page numbering of item 81 in this matter. And Mullahs, I am not, for a minute, we are not seeking the court to get into the domain of expert, because the learned cat has actually gone into the domain of experts. They find the problem in the questions, but they say what we can do. Exactly what I heard from that is why I want to show paragraph number 107.
Printed or?
Mullahs, may take printed 108 of and PDF 114, Mullahs. Well, this internal page.
Sir, just a minute. I think
please.
Paging is printed page
108, Mullahs, of
108. Yes, sir.
Mullahs, does it say paragraph 13?
12.
However,
no, it starts with para 12.
All right, Mullahs. Then Mullahs, may kindly come to para 13 then, Mullahs, of Mullahs file. However, it starts with however.
Just a minute. Yes, however, it is page 1.
The callous.
Yes, sir.
Mullahs, may I be allowed to read?
Yes.
However, the callous and casual attitude of the experts of SSC has floored, flummoxed, flabbergasted us on the sheer scale of 22 questions, where grace marks were awarded to all the candidates, even those who had not even attempted the vague disputed questions or giving wrong answers to the doubtful questions. Exactly the question that my lord is saying. Also, we are puzzled and perplexed that while the tentative answer key was vetted and endorsed by experts of the SSC, pausing here for a minute, that's my case. That the tentative answer key that I had shown, Mullahs, had the right answer. It was also vetted by experts. Then I move on, Mullahs. Later, the experts, after getting feedback from applicants across the country, had to change their view in not just one, two, but 22 questions. That's the grievance that I'm presenting before my lord. We are therefore of the opinion SSC should have been wiser and more erudite experts are on their panel who sets totally unambiguous questions which are clear cut answers in future. Moving to the mid of the next page, Malas, it started with, hence we refrain from commenting on the same. However, we could not stop ourselves from mentioning that in one question, the candidate who attempted English has rightly attempted, but he's being made to suffer because of the anomaly in Hindi version. And the candidate who did not attempt the question at all stands to benefit. This is definitely a point to ponder. The SSC should come out with a clear policy which will go a long way in reducing litigation in these trivial issues. The point that on the last occasion, even this bench also pointed out. As the part, we would like to express our dismay and disappointment on the unlevel playing field created by SSC by giving grace marks to all candidates who had not even attempted an unambiguous doubtful question or gave the wrong answers to these unambiguous questions. We, however, sanguine that SSC would be more circumspect and cautious in the future, and their attitude will not remain as casual. Now, this is where the impugn order stops. Because I ask myself a question, Mullahs. I completely understand the honorable cat has gone into the details. They have found these 22 questions problematic, but no relief has come to me. So I suffer. I continue to suffer. Nonetheless, the question that I'm asking myself is this, when I come to this court, is because there has to be some solution that has to be found. I'm not, my prayer is quash the entire result. I understand, Mullahs, as an officer of this court, I cannot ask for that prayer. And I very fairly say that. But Mullahs, 22 questions. Please see, Mullahs, if I am at 290, deserving 290, somebody who is given wrong answer is at 343, gets the rank, gets the job also. The posting has also happened. Because this is the only grievance I have, and we are before Mallard's and in Mallard's hands completely. Because there can be one way, because either there can be a prorated way of giving us marks which will better our ranks. Maybe we get our prospect correct. That is for SSC to ponder on. Or there can be some other way. Well, it can be that for the question that I have answered, at least for the petition that have come, maybe the marks can be given to us as a benefit for all. If I had given that question rightly, no benefit is coming to me, so 3 marks prorated can be given to me. There has to be some solution found out by either SC simulars, or we have to sit together and do this. Is 130 people, 60 out of us is the last opportunity. We have lost the opportunity. That's my grievance and that's my case before Mullahs.
Yes, sir.
So the judgment that I wanted to show, Mullahs, of the Honorable Supreme Court, if I may point.
Yes, sir.
On the last occasion, my learned friend for SSC had pointed out that this Honorable Supreme Court says the benefit of to all is the norm. Please have paragraph 12 of this judgment, Mullahs. The three-judge bench of the Honorable Supreme Court. Just opposite. They say benefit of for all cannot be granted. Paragraph 12, Mullahs. There is yet another problem, Mullahs, which Mullahs has. May I read? There is yet another problem, namely that for 7 questions, which are so vague that they are incapable of having correct answer, the appellant university, in respect of those 7 questions, has given the credit to all the students who had participated in the entrance test, irrespective of whether someone had answered the question or not. Same as my problem. We do not think that this is the proper course to follow. It is wholly unjust to give marks to a student who did not even attempt to answer the question. This course would mean that a student who did not give the answer, say all the 7 questions, would still get 28 marks for each correct answer, having 4 marks. The reasonable procedure to be followed, in our opinion, would be to give credit only to those who attempted the said question, or some of them. Having regard to the circumstances of the case, we direct that students who attempted those questions are some of those questions. Insofar as they are concerned, the said question should not be treated to be a part of the question paper. Like Mullahs had lastly pointed out on the last, why don't they discard those questions? This is exactly the Supreme Court answering that question. To illustrate, if a student answered all the said seven vague question, insofar as the student is concerned, total marks would be counted to 772, that is 800 less than 28. And likewise, depending upon number of such questions, if any answered by student, the 7 vague questions are question number 4, so and so, so and so, so and so, so and so, so and so. Well, this is the position of the Honorable Supreme Court in a similarly placed case, that I am presenting before my lords. And I had also mentioned this one division bench judgment of our own court, which had actually gone into details of questions. If I may just for the knowledge, if
Pass on, sir. Pass on.
may kindly have, I will not bother Mullahs much. Mullahs may kindly have paragraph 39. where this honorable court, another definite bench, as I had pointed out, has gone into detail of every question and has declared those questions to be not vague. Because I will emphasize again on the point, Mullas, that the tentative question key, the answer key that came, had the right answer. They say that later on that we find it unambiguous and therefore giving marks to all. And therefore, the Honorable Supreme Court judgment comes to my benefit, saying that this was not the right course of action.
Right, sir. Anything else, sir?
Plus, I am before Mullas.
Lordship, my learned
Lordship,
friend has
if I
just
may,
passed on a Guru Nanak, that judgment. I'm just passing on, Lordship, that Balram.
First,
Sorry.
all right, we'll come back after 2 minutes, madam. 12 o'clock.
Oh.
We'll come back and
Please, Your Lord.
yes, ma'am. What do you want to say?
Supplementary.
One, as for that, there was no 22 question, only 19, and last one, the last day, I gave that there were 4 subjects and inputs. And secondly, Lordship,
No, what is the bifurcation of these
Yes.
9? Because what I find from your report is that there were 1, 2, 3, 4, 5, 6 sections.
no,
Hmm. Total 260 questions.
yes. And out of that, has multiple answers. What is under channel? One was reasoning, in which 5 questions out of 60.
Reasoning 5 out of 60. Hmm.
Second was quantitative aptitude, that is 5 questions out of 60.
Aptitude,
Quantitative,
quantitative aptitude. Yes. How many questions are wrong?
that is 5 questions
Out of?
out of 60.
All right.
And third is the general awareness, that is 7 questions out of 50.
7 questions out of 50. Hmm.
And third was
Hmm.
English language and comprehension,
Hmm.
that is 2 questions out of 1. So each questions discussed.
Hmm.
What my learned friend relied on.
Hmm.
One was Guru Nanak, and the other was Subhampa.
1 minute. Out of those 19 questions, what manner were they wrong? You are ambiguous answering or multiple answering?
Can be both ambiguous or multiple.
Can be
Means
obviously.
out of 19, so I can't identify whether it was ambiguous.
I can't you identify you can.
Not if it is not in the report because
You must have been seen that report. That
because ambiguous and multiple answers.
how
No,
many were ambiguous and how many had multiple answers?
Lordship, one that could be any reason, either there is no correct answer.
Out of the options given.
Yes.
Multiple options.
Multiple.
it was MCQ.
Yes.
So those 19. Let's say had more than one correct answer.
Sample.
How many that would be?
That we have not got to the Lordship.
In any case, we'll be calling you later. But in the meantime, we do this exercise. Find out what is the problem in each case, separate. Could be general, specific problem. If one question had multiple answers, then all the multiple answers were available in there itself, in those 4 options.
Yes, if suppose the question has 2 answers and both the answers can be.
possible? How many of these 19?
That will work out and that will continue.
Please tabulate. We'll call you at 2 in our chamber. We would like to discuss with you because it's each question and then satisfy yourself whether what is to be done in this case, right? Yes, madam. Apart from that, what do you want? What else you want to say?
Panel pointed out, and Guru Nanak Dev and the other is Shubham Pal. Watching the judgments of Shubham Pal, which was answered this on the court, is under challenge in Supreme Court, and Supreme Court has given a stay on that. And the SLP number is 1590 and 1591 of 2025.
That's the law. Court is not going to the domain of experts.
Yes, Lordship. And secondly, Lordship, there is one more judgment I'll just pass on. That is Balram Vishnu.
My memory serves me right. There is one judgment from Rajasthan and one judgment from UP where this entire aspect has been considered by
Ranvijay Singh,
Ranvijay.
UP.
And there is one judgment from Rajasthan.
Yes.
Is also
Lordship, the judgment which I have just passed on, Your Lordship, may kindly, if Lordship, I'll not bother much, I'll come straightway to the, because the subject is, the issue is same. Now I'm just coming to the point, page 7. May I?
Yes.
Read, Lordship? It is submitted by, I read from there. It is submitted by Mr. Tushar Mehta, Learned Additional Solicitor General, that the said decision could not be applicable to the case at hand. Learned Counsel for the respondent number 2 would submit that there was no provision for negative marking for incorrect answer in Guru Nanak Dev University. We find that in the reported decision, there was no stipulation that if a candidate attempt a question wrongly, there would be a negative marking. That apart, only 10,000 students appeared in the concerned examination. In the present case, as Mr. K.K. Venugopal, Learned Attorney General for India, would submit on obtaining instruction that 156,000 students actually appeared in the examination. In our case also, 153,076 students appeared. In such a complex exercise, to apply the decision of Guru Nanak Dev University case would not be opposite, and in our considered opinion, the said decision is distinguishable. This being the position, we are inclined to vacate the order passed on 7th of July 2017, and we do so. They are given stay, Lordship. On vacating the order clearly conveys that we are not inclined to interfere. If any matter is pending before any High Court, the same shall not be entertained to avoid any kind of confusion. After saying so, we would have proceeded to dismiss the writ petition, but the desire of this court is that such kind of error, mistake, whether printing or framing of questions, should not occur in future. Mr. K.K. Venugopal, Additional Learned Attorney General, Mr. Tushar Mehta, Learned Solicitor General, and Mr. Sonal Jan, Learned Counsel appearing for the respondent number 2, shall appraise us with the regard as to the opposite foolproof mechanism by which no mistake shall be taken in future. So, Lordship, in this and another one judgment.
Tell us what mechanism has been adopted despite, I think, last 25 years the courts have been flagging this issue. What steps have been taken by these agencies?
May I allow you?
Lordship, in this case, when the questions are framed, there are 3 levels. The agencies are supposed to have 3 levels. One is the question, the content creator, and all the 3 levels, they are members of the academia. Then there is an evaluator, and then there is a vetter. There would be a translator, and then there's a translation vetter.
So if in 3 levels, the so-called experts can't identify that there were number of vague questions, vague answers, then what sort of experts they are, sir?
You are right, Your Lord.
And they claim themselves to be experts, sir.
That is correct, and that is why we have got.
So what steps have been taken despite Supreme Court saying, various High Courts saying, please take corrective steps. You are playing with the future of the country, sir.
Your Lordship, last time, this mechanism which was there, after a judgment of the Supreme Court that the exam conducting work and content creation work uh, should not be given to one agency. So that has been done. We have moved on to a completely different dispensation. Unfortunately, there also, I'm not saying that we are having a very good result, but we have moved and we continue to uh, improve. And Lordship, there questions are created.
19 question does not show any improvement. It shows deterioration.
It is definitely very high percentage, Lordship. 7% is the, if we go by percentage, and our threshold is 2%.
Lordship, just
Please take the money back you have given to the expert for framing the question. Take the money back.
We do, Your Lordship. In this case, there was very heavy penalty. If Your Lordship would have gone through the papers,
Have you given this work also to contract on contract basis? That questions framing will be on contract.
this was being done by the exam conducting agency. Now it's yes, we did float a tender. We have different agencies and
For framing questions.
for content creation,
Content creation. Content
in the new. We do not have experts, Your Lordship. We do not.
If we are floating tender for this purpose, then God save this country, sir. Then I don't think we are left with any hope, sir. But if questions are being drafting question paper, you are giving tenders.
Lordship, in the Supreme Court judgment in Shantanu.
Then why these all these employees are there in the department and selection bodies?
There has to be an independent body, Lordship. The employees will create, and then we'll have to have a panel of experts. The employees who are there, they are generalists.
Mr. Counsel, I can tell you, sir. I don't know, sir, what post you are holding.
I am director.
Please go back and introspect. Are you or are you not playing with the future of the country, including your own children? Please, God's sake, go back and introspect, sir.
they are trying to put a mechanism in place, but the professors and others.
Madam, I can tell you, first judgment was in 90s, and today we are in 26. There is a deterioration, not an improvement.
Because 2% only they can have that. Going to the Lordship, just only last one more judgment I will point out. And in my counter, there is a Mahesh Kumar judgment of Supreme Court. That's all I have. May I read that?
It really pains us a lot.
We have all come through that.
What steps have been taken?
What director is saying that we are trying to change the system of giving it. So different agencies.
We are that's what we are doing. Floating tender.
Lordship, floating tender is for the conducting of the examination. Now, only the professor has to come. We have
Lordship,
to
there,
get the help of.
Madam,
Okay,
just
okay,
tell
let
me.
me-
If a examiner is unable to identify after 3 levels of scrutiny that there are certain weak questions, then I am sorry, I will not call him expert. I will say he's a illiterate man. What's an illiterate man? What's an illiterate man?
I'll just put forward a few points, Lordship.
Basically, only thing is our hands are tied because of some Supreme Court judgments. Otherwise, look at the face of children in the morning. What we are doing with our children. We have totally become insensitive. If our future is not safe, all this development will be of no use. And all these assets will remain here only. Even Sikandar went empty-handed. All right, what else? You want to say anything else apart from Mahesh judgment?
No, Lordship.
You have said that, sir.
Please, Lordship.
Please come at 2 o'clock in the chamber, sir.
Lordship.
Hmm. All right, we'll examine, sir. The petitioner argument is over. Now we have heard respondent. Now you will start with the petitioner, sir. Yes.
2 o'clock.
Arguments heard, judgment reserved.
Lordship at
2 o'clock, sir.
please.
In my chamber, sir.